Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help people out with employment law, personal injury, and family law needs. Today's video is going to cover eligibility for a protected leave under the Family Medical Leave Act, or FMLA. And for the purpose of brevity, let's just refer to it as FMLA or the FMLA rather than the whole name. To be eligible for protected leave under FMLA, you need to meet three elements. Number one, your employer must be subject to the provisions of FMLA. Second, you must be an eligible employee. And third, you must be entitled to leave for a qualified reason as described by FMLA's statutory or regulatory provisions. So we'll talk about each of these elements and the specific rules that apply and how they roll up together into a request for FMLA leave. So first we'll talk about the standard to which an employer must meet to be covered by or subject to FMLA's provisions. There are three types of employers that are subject to FMLA. First, a public employer, meaning a government agency, is subject to FMLA. Second, any public or private elementary or secondary school is a covered employer under FMLA. And third, and this is the most common but also most complicated rule, is a private employer with a certain number of employees. And the calculation for the number of employees is that the employer must employ 50 or more employees within 20 work weeks or more, 20 or more work weeks within the current or preceding calendar year. So let's unpack what that means, because this is a rule that applies to lots of employees. The way to calculate whether the employer had 50 or more employees is to look at each individual work week within the calendar year. In looking at whatever the employer determines is a work week, we look at the number of employees. If there are 50 or more, that counts as our work week, and we just need to get up to 20 of those weeks within either this calendar year or the prior calendar year. We can't combine the 2 years together, but one or the other is enough. So if, say, the employer had 50 employees each week of January, February, and March, and then somebody quit, and now they have 49. I guess that's not enough months, but let's say that they had 50 employees each week through January, February, March, April, May, June, July, and August. I think that's 20. And then, yeah, that's 20. So we've got more than 20, and then in September, one of the employees leaves. They have 49 employees. If you go up and ask for FMLA leave in December, you're still fine because the employer has met that 20 work week requirement. Now, let's say maybe the employer has had 49 employees every week this year, but last year we can find 20 weeks where there were 50 employees. That's fine. We can still have a valid FMLA request this year based upon the preceding year's employment numbers. What we can't do is combine those together. So if we found 10 weeks this year and 10 weeks last year, but in all other weeks they had 49 employees, you're out of luck. This often isn't a big rule or a big problem. If you work at a large employer, if they've got 500 employees, they've always had 50 employees or more. You're fine there. But when you work for a smaller employer, they often look at these numbers to determine whether they're going to fall subject to these rules or these laws, and the employer may be carefully monitoring and trying to avoid having 50 employees within those 20 work weeks. So that can become really important. And an employer's assertion that they haven't had enough employees through the year is not by itself a definitive answer. You've really got to go in and count the numbers and determine who was an employee and when did they work and during what work weeks did they work and so forth. But let's say that we can figure out that the employer is covered, they're subject to FMLA. Now we've got to figure out, is the employee eligible for FMLA leave? And there are 4 elements here that the employee has to meet to be an eligible employee. Number 1, the employee has to work for a covered employer. That seems pretty obvious. Number 2, the employee has to be employed for at least 12 months with the employer. This calculation can become complex, and we won't get into it, but there are certain circumstances where employees who have worked for an employer for a little while, left, and then come back can bridge that service together to count up the 12 months to take FMLA leave. But like I said, that's more complex. I'll probably talk about it in a future video, but for now, just know that the employee needs at least 12 months. The employee also needs, number 3, at least 1,250 working hours during the past 12 months. With one exception that applies for airline employees who primarily work on flights. But for all other employees, this rule is exactly what it says. You've got to work that 1,250 hours within the preceding 12 months of the leave request. Now, it's important to distinguish that although there are some circumstances where service can be bridged together to meet the 12 months of employment, the hours worked cannot be bridged from period to period. They have to be within the past 12 months. That doesn't mean that the employee has to have worked for the employer for the prior 12 months, but just that that number of hours has been logged in employment for the employer. Working at 40 hours a week, that gets you to a little under 32 weeks or 8 months of work. But of course, if you're working overtime, you'll hit that number much quicker. And of course, this is one of those points where hours worked could become contentious in calculating FMLA leave eligibility. If you're working time off the clock and the employer isn't paying you for it, number one, you probably have an overtime pay problem. But secondly, you may have an issue you may have an issue with your employer calculating that eligibility. If you're a salaried employee where time records are not carefully kept, that can become a problem in itself, showing that you normally work a certain number of hours and maybe you're working more hours and the employer just isn't tracking it. In that case, you're not going to have an overtime problem because most salaried employees are not paid overtime and are not eligible for overtime, but you may still have a problem working with your employer to show, hey, look, I normally work 45 or 50 hours a week, even though you're not keeping time records of it. I am already eligible. I've got this 1,250 hours logged or worked, even if it's not logged. But let's assume that the employee has the number of hours. The last requirement, and this is another tricky one, is that the employee works at a location where the employer has 50 or more employees within 75 miles of that location. Here's how this rule works. If you work at a work site where there are 50 or more employees in the building or whatever that work site is, you're fine. Where this becomes a problem is if you work for an employer that, say, has maybe lots of franchise locations, or they have lots of traveling employees who might work from home and don't ever go into a central office and, travel by plane or car or whatever. In that situation, you've got to get out the map and draw a 75-mile circle around wherever you normally work and start counting employees and find 50 employees within that area. If a workforce is broadly spread out, the employer might have 50 or more employees to be subject to FMLA, but they may not have the 50 employees within your radius to make you eligible for FMLA leave. And both of those calculations are separate. Now, to be eligible, you don't have to show that 20 or more work week part. You've just got to show that there are 50 employees within that radius, and that will make you eligible. For most people, like I said, this isn't a problem, but when it is a problem, it really can be a problem getting out the map and figuring out, number one, what is the employee's normal work site, and number two, do we have enough employees within the radius of that work site to make that employee eligible for the leave. And third, the employee must be entitled to leave protected by FMLA under FMLA's provisions. And there are 5 reasons that an employee may take protected leave under FMLA. If a leave request does not meet one of these 5 reasons, then the employee's request would not be protected by FMLA, and the employee would have to work with the employer to find some other alternative for leave. So the 5 reasons presented by FMLA is number 1, a child's birth, and that could be that the employee is either mother or father to that child and still take off leave. Number 2, adoption or foster care. If a child is being placed in your home, either through adoption or foster care, you can take protected leave. Number 3, the employee requires care or treatment for a serious health condition, as that term is described within the statute. Number 4, care for a child, spouse, or parent with a serious health condition, as described within the statute. And number 5, a qualifying situation from a spouse, child, or parent who is a military member on active duty or called to an active duty status. And the statute and its regulations define what these qualifying situations are, and these basically relate to problems that arise with the call to active duty and how it affects the family, or certain other things that occur as a result of being on active duty or called out to active duty. Might be worthwhile to set up some separate videos to discuss both what the serious medical condition is under FMLA and what these qualifying situations are under FMLA. But at a minimum, just for sort of a high-level video, I think it's worth just pointing out that these are the basic reasons, and there are specific statutory requirements to be a serious medical condition or what's called a qualifying exigency under FMLA for leave. But if you've got a covered employer with an eligible employee making a leave request that's entitled to protection under FMLA, then the employee is entitled to up to 12 weeks of protected leave within a 12-month period, but up to 26 weeks if the request is for the care of a spouse, child, or parent who is a service member who has a serious injury or illness caused by active duty, and there's specific meaning about what those serious injuries or illnesses are within the statute. And I should point out, actually, for that service member leave, the 26 weeks, in addition to a spouse, child, or parent, it also includes a next of kin, which is another term described specifically by FMLA. But for the most part, most employees, their request is going to be capped out at 12 weeks of leave within a 12-month period. And there's a few different ways that employers can calculate that 12-month period. And again, completely worth discussing in a separate video. I also have it discussed on my website. So if you're looking for something immediately to try to understand it, it's definitely out there on my website. But at any rate, if you've got that leave request, you're protected for the period of time that applies to your request. And it's worth pointing out that just because you make a request, that does not mean that you're automatically entitled to all 12 weeks. If your request only needs or only describes 3 weeks of leave, you don't get automatically all 12. You just get the 3 weeks that you've requested. Anytime a leave request comes in for a serious medical condition for the employee or for a child, spouse, or parent, the employer is entitled to request medical certification in which the treating physician explains what the condition is and how long leave will be required. And there's specific forms employers can use, or they can come up with their own form for certification, but they've got to be careful to keep in mind HIPAA requirements and to only ask for the amount of information that FMLA authorizes them to request. A certification is not required for childbirth, adoption, or foster care. Oftentimes, the employees talk about these things occurring months in advance, so the employer shouldn't be caught off guard by them, but they're not entitled to certification for those reasons, although if the request is for a serious medical condition related to the pregnancy or a later effect from the pregnancy or childbirth, that may require certification. And when in doubt, oftentimes it just makes sense to provide the certification rather than fighting with the employer over it. But it is important to know the difference between when certification is required and what information needs to be provided in certification. That's something else that will probably go into another video and certainly is discussed more on my website. But that's the basics behind FMLA eligibility. I hope this video was useful as the others. I would say if you've got questions about taking FMLA leave or how your employer has responded to a request for leave, you should definitely talk to an employment attorney and get ahead of any problems that might arise. If you have a medical need or childbirth or a child is being placed into your home, it does far more benefit for you to work that situation out with your employer ahead of time versus creating problems in the midst of all of it and try to plan for a surgery or take time off for a surgery or recover and then have to worry about whether your job is going to be there or what's going to happen to your job while you're gone. So it's best to start working on it ahead of time if any problems seem like they might be out there, or if something has gone wrong with your FMLA request, you definitely need to talk to an attorney as soon as possible to both, either to try to get your job back and fix the situation or to prepare claims against your employer, depending upon whatever's most appropriate for your situation. So that's basically it for this video. If you've got some other questions about FMLA or you're looking for more information, my website has plenty of other useful pieces of information out there. It goes into more detail on several of the issues addressed here. There will be links below in the description. So that's pretty much it. Thanks for listening, and I'll see you next video.